you would be looking at a first-degree felony if you're found guilty for punishment purposes, which means the minimum punishment would be 5 years up to 99 years or life in prison. You understand that? And the same offer is on the table now, which is a 20-year term in prison that would be stacked on top of a sentence that you're currently serving. Is that your understanding of what they've offered you? And you want to reject that and move forward with trial?
Yes, ma'am.
All right, we'll get it set on the trial docket. Mr. Radford will begin preparation for trial.
Excuse me. That time that I'm actually doing time for right now already, that's on appeal.
Okay,
But that's not a full conviction.
all right. Well, if it'll all depend on when we get to the trial. I'll set it on the trial docket. If something gets affirmed by then the conviction would count. If not, then there's some legal issues that will take up at that time, which means it would be potentially just the 2 to 20, but we'll take that up at pre-trial.
Judge, it looks like a case has been brought over this week from something that happened in the jail. It may be a new harassment or assault on an officer. I think that's going before the grand jury tomorrow, if not tomorrow, next week. And I just asked that we put this on the trial docket. I don't think it's going to change.
No, yeah, we're going to go to put this one on the trial docket and then we'll deal with that one when it comes.
Thank you.
Thank you, Mr. Nichols. You can go back with the bailiff.
May I be excused?
Yes, the offer was 20
Yes, stacked.
to stack on top of a sentence he's doing now, correct?
Yes, ma'am.
All right, so you're Jacoby and Dorsey.
Yes, ma'am.
And Mr. Dorsey, in cause number 25, DCCR 1896, you are charged with manslaughter. And we've gone over this before. Let me pull it up. Is there the indictment alleges second-degree felony offensive manslaughter, but looks like the state's filed a notice of intent to use prior conviction to enhance your punishment, which means we've gone over before. And when you sign that plea bargain rejection with Mr. Parker, that the state motion.
She will, Your Honor.
Ms. Yell, in cause number 22-40915, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 4th of 2023 for the state jail felony offense of credit or debit card abuse, and that was a 4-year deferred probation. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of driving while intoxicated with a child under 15. And is that true or not true?
True.
Count 2 alleges that you failed to abstain from the use of intoxicating substance, including alcohol, and that on March 22nd, you were intoxicated or under the influence of alcohol. Should that say the same date? The first one says March 20th and second says March 20.
With the court's permission, I'll amend to make that the 20th.
Any objection?
No objection.
So it's just alleging that you were intoxicated on the same day that you were arrested for the DUI. Is that true or not true?
True.
And Judge, I think we've agreed to abandon counts 3 and 5.
Judge, we can drop 3, 4, 5, and 6. It's all right with the court since we have an agreement.
Thank you. State will abandon 3 through 6. Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Did you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Yell is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and your plea is of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty and find you guilty of debit or credit card abuse. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison.
Judge, the agreement to 1 year in the county jail.
Good grief, I'm all out of whack. 1 year in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long. Good morning, sir. Are you Joseph Curtis Jr.? Speak up, please.
Yes, ma'am.
And this is cause number 25 DCCR 1758. Mr. Curtis is charged with continuous sexual abuse of a child. And what is the announcement?
We would like to hold and not ready at this time. We have some mitigation we would like to get, and we haven't been able to speak with Ms. French.
Judge, I know that Mr. Johnson had reached out to Pam in after the last setting, and they were working on getting some information to her that I think is mitigation evidence. So I don't see a problem if it's all right.
So this has been. It looks like Mr. Johnson substituted in December of 2025. I'm going to reset it one more time. That will be the final reset.
Yes, ma'am.
So whatever needs to get to Ms. French needs to get there quickly, so that she can take a look at it. And if that changes anything with regard to an offer, y'all can discuss it and have an announcement before the next. Freely and voluntarily. And did you plead guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes,
Do you fully understand them?
yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1,
Objection?
it's admitted. Is there any evidence that Mr. Bell is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated, 3rd or more. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will also, as part of that plea agreement, sign the dismissal in cause number 25 DCCR 1211. I'm handing you the trial court certification. Shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Ronald Barrett.
Can we do?
Ronald Barrett.
Wait, go ahead. What Tom's case?
Looks like Mr. Nichols is on that one.
We've got it covered.
Yep, got it.
I'm just letting you know, I mean, y'all wasn't saying today.
Actually, it's my case. They've been, most of it has been.
It said Tommy.
No, it's no longer says.
On my reset, sorry.
You've been around this. Sorry, case.
Good morning, sir. Are you Ronald Barrett Jr.?
Yes, you know.
And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Barrett, in cause number 26 DCCR 0890, you're charged with the state jail felony offense of unauthorized use of a vehicle.
Yes, ma'am.
And that's from January 28th of 2026.
Yes, ma'am.
The indictment alleges that you were previously convicted of unauthorized use of a motor vehicle August 3rd of 2009.
Yes, ma'am.
And after that was final, you were convicted of possession of a controlled substance March 22nd of 2011.
Yes, ma'am.
And then after that, convicted of unauthorized use of a vehicle April 14th of 2011.
Yes, ma'am.
And then again, unauthorized use of a motor vehicle June 26th of 2017. And then burglary of a building August 24th of 2022.
Yes, ma'am.
And how do you plead of that charge?
Yes.
And are all those prior convictions true?
Yes, ma'am.
I don't understand this agreement at all.
Judge, the vehicle in question is a scooter taken from a known address. The complainant is well known.
And I,
Of me in the
and
court.
I will also tell that there's been some cooperation with.
Okay.
law enforcement.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And obviously you can tell that I don't like this agreement, but I understand there's some circumstances that Mr. Nichols and Mr. Parker have negotiated for that.
Yes, ma'am.
I want you to understand if you come back in here on another offense where you're stealing a car or getting into a building or stealing, I don't care if it's a scooter, I don't care if it's a Snicker bar.
Yes, ma'am.
You will not get an agreement like this again, regardless of what you've done. Do you understand?
Yes, ma'am.
Do you also understand if you're not a US citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection?
It's admitted. Is there any evidence that Mr. Barrett's not competent?
No, you're right.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Also that you entered those pleas of true freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of your plea.
Yes, ma'am.
Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Find this prior offense is true. Sentence you in accordance with your agreement to a term of 2 years in the state jail, in the Texas Department of Criminal Justice.
Yes, ma'am.
You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal.
Yes, ma'am.
I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yes, ma'am.
Possession of a firearm or ammunition could lead to charges against you.
Yes, ma'am.
If you have any questions about the laws that make you ineligible to possess a firearm or ammunition,
For this crime.
He's on parole for possession.
Oh, yeah, I mean.
oh, yeah.
Parole hold, I'm thinking of parole hold.
Oh, I was like, how could it be on? Very confused for a minute. Good morning, sir. Are you Anthony Cassio?
Yes, ma'am. Good morning, Saturday.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Cassio, in cause number 26 DCCR 0902, you're charged with the state jail felony offense of tampering with electronic monitoring device. And that's from March 29th of 2026. And how do you plead to that charge?
I was talking to my lawyer about,
It's either guilty or not guilty. Or go to, if not guilty, you can go to trial, or if you did it, it's guilty. Are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
yes, ma'am.
Do you fully understand them?
Yes, ma'am. I had a few questions.
What's your questions?
I was told that I wasn't eligible for a 1244 because of my prior, but I only have one prior.
So it's not a matter of if you're eligible or not. It's a matter of if that's what the state's offer is, and it is not that. This is what the offer is. So it's you either, again, take this offer or go to trial.
Take me.
Any other questions? So, before you signed these, you went over with them with Mr. Parker though, right?
Yes, ma'am.
All right. And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And do you also understand if you're not a US citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Cassio is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of tampering with electronic monitoring device. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Sean Johnson,
It's rejection. He may be, he may be. This.
snowboarder. Isn't that his name?
Huh?
Yeah, the snowboarder.
Oh. I was thinking of the gymnast.
Oh, yeah. Probably. Okay,
That's what I thought.
no, getting confused.
Sean White.
Yeah.
Right. Sean Johnson is the gymnast. Probably not the same, definitely. Good morning, sir. Are you Sean Joe Johnson?
Yes, ma'am.
And Mr. Johnson, in cause number 26 DCCR 0924, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from March 6th of 2026. Your indictment alleges that you were previously convicted of burglary of a habitation, a second-degree felony, July 8th of 2016. And then after that was final, you were again convicted of burglary of a habitation, a second-degree felony, February 15th of 2017. And what that means, sir, is that if you go to trial and you're found guilty, you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or life. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker, and I'm guessing you guys, it says months are checked off.
I'm
guessing
sorry.
it should be years.
I'm calling it, yeah.
So it shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 12-year term in prison. You have every right to reject that offer and have your case set for trial. Just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to plead guilty. Do you understand all that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Johnson, Mr. Parker has been appointed to represent you. He's one of the cases. He's one of the lawyers who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and appoint a new attorney who could begin preparation for trial a little quicker. Is that okay with you?
I'm gonna do a turn.
So I'm going to release Mr. Parker. We will appoint someone today, Mr. Johnson. They should begin preparation for trial very soon. Mr. Smith, is there any reason to believe or anything that you're waiting on that offer would be reduced with a different attorney? So I do want to make sure you understand that a different attorney is not going to necessarily get you a different deal. And that typically after today, I don't take those deals that you've already turned down. If something comes up that's different that your attorney doesn't know or the DA, then I'll consider it. But whoever that is will be out to see you very soon and begin preparation for trial.
Yeah.
All right, you can go back with the bailiff.
Look. All the other one I have is a Jericho Thomas. It's likely to be a rejection, but I need to I haven't got the video yet.
Okay, do you want me to bring them out or just,
It doesn't matter to me,
you
Judge.
can just let them know that we're gonna reset it for you
Okay.
to get the
I
video.
told- I told
Jericho
them.
Thomas. They'll just say to get the video that way. Thank you, ma'am. See, Miss Holmes, you got Stormy Fulwell.
Over the motion, we can do an updated PSA.
I think you need to know exactly what you're gonna do on this one, though.
Yeah.
Oh, I do. Y'all do?
Mhm.
Well, I wouldn't prejudge. Is it that clear?
She's very clear.
Oh.
This is one of those special drug things that the minimum is 10. But she pled.
She's
She's been to St. Pete twice.
Good morning. Are you Stormy Fulwell? And will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Fulwell, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Ms. Fulwell, in cause number 21-38655. I have a motion to revoke your community supervision. Shows that you were placed on probation January 26th of 2022 for possession with intent to deliver a controlled substance, a first-degree felony. And that was a 10-year term in prison that was probated for 10 years. Is that correct? The motion alleges that you violated your probation. It alleges in count 1 that you provided a urine sample January 26th of 2026 that tested positive for methamphetamine. Is that true or not true? January 22nd of 2026, excuse me. Is that true or not true?
Yes, sir.
True or not true? Thank you. Count 2 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
True.
Count 3 alleges that you failed to successfully complete the SafeP program and that you were unsuccessfully discharged from the supportive outpatient treatment on January 22nd of 2026 because you tested positive there for methamphetamine, amphetamine, and ecstasy. And is that true or not true?
True.
Count 4 alleges that you failed to submit to alcohol or drug screening January 21st and February 2nd of 2026. Is that true or not true? But that is not true. Count 5 alleges that you're behind in your court assessed fees as of February 6th of 2026 in the amount of $4,205. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I'm going to reset your case for sentencing and ask the probation department to do an updated report that'll give me more information about what's been going on. Also, if there's anything that you think is important for me to know, get that information to Ms. Holmes and she'll present it to me on your behalf when we come back. All right, you can go back with the bailiff. Thank you for being here, ma'am. Good morning, sir. Are you Jasmine Tyrone Hancock?
Yes, ma'am.
And Mr. Hancock, in cause number 25 DCCR 0737, you're charged with the state jail felony offense of evading arrest or detention with previous convictions. And that's from April 22nd of 2025. The indictment alleges that you were previously convicted of evading arrest or detention August 9th of 2013. Some of these are with vehicles, which would make them different. Looks like we've got an evading with a vehicle, April 23rd of 2008, another evading with a vehicle, December 1st of 2008, and evading with previous convictions, June 12th of 2017, and evading also with previous convictions, June 12th of 2017, and evading with a motor vehicle, 2 cases on June 12th of 2017. Then the indictment further alleges that you were convicted of unlawful possession of a firearm by a felon, February 9th of 2009. Also possession of a controlled substance on that same day. And then after those were final, you were convicted of burglary of a habitation, June 12th of 2017. And what that means is that if you go to trial and you're found guilty and those prior convictions are true, the range of punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
So in clause number 25, DCCR 0738, you are charged with the 3rd-degree felony offense of continuous violence against the family, and that's from April 26th of 2025. And it alleges those same prior felony convictions, which in this case means that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life. Do you understand that as well? And then we've got cause numbers 25 DCCR 1233, which is another evading arrest or detention with previous convictions. And that's from August 5th of 2025. And then we've got 26 DCCR 1018, which is also an evading arrest or detention with previous convictions from March 18th of 2026. Those are both the same as that first one with those prior offense convictions that would make these second degree felony offenses for punishment. You understand that? In all four of these cases, I have here on the tablet some plea bargain rejections that you've signed with Ms. Holmes, and it looks like the district attorney's office has made offers if you wanted to enter pleas of guilty. For the evading arrest or detention cases, it looks like it would be cause number 250737 and
I think I did.
1018. There would be 12-year terms in prison with dismissals in the other evading and that continuous family assault case. You have every right to reject those offers and have all of your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are if you want to plead guilty.
Yes.
You understand all of that.
Yes.
I also want to make sure you understand that if you are found guilty on more than one of these, because they're different offense dates, there is the possibility that any sentence you receive on more than one could be stacked on top of each other. Do you understand that?
Yes.
And do you want to reject all of these, the offers on all of these cases and have them all set for trial?
Yes.
Mr. Nichols, is there any reason to believe that these offers would change or?
No, Your Honor.
So I do want to make sure you understand also, Mr. Hancock, that after today, I will not accept these plea agreements.
Yes.
Once your case goes on the trial docket, it goes to trial, or you can enter a plea either open to the court or to some different.
Yes, ma'am.
You understand all that?
Yes, ma'am.
All right, then we'll get it set on the trial docket. Mr. Hancock, Ms. Holmes has been appointed to represent you at this point. She's one of the attorneys who handles a lot of cases for me as a court-appointed attorney.
Yes.
With your permission, I can release her and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So Ms. Holmes, I'll release you. We will appoint someone today. They should be out to see you at the jail very soon to begin preparation for trial.
Yes, ma'am.
All right, you can go back with the bailiff.
All right, Brittany, thank you.
All right. And Mr. Johnson, in cause number 25, DCCR 1775, you're charged with the second degree felony offense of aggravated assault with a deadly weapon. And it looks like. Has there been I guess I'm confused. Because the offers,
25, should be 20. It's 2 to 20.
it's a 2 to 20, and I don't see, is there going to be, or has there been, I don't see a notice of extraneous other convictions.
There is no, that's right, Judge. It should, the max is 20, Judge.
So really, there's no offer. It's just to plead open or plead guilty to the max. Is that?
Judge, I was on the impression it's first degree. Let me
don't you
draw
pick-
that offer.
Yeah.
The state's offer now is 15, Judge.
Okay, I'll hold it for a minute if y'all want to visit about that, or I can.
We've already talked about Judge.
Okay, so it doesn't matter if
It
it's-
doesn't matter.
Okay, so with everybody's permission, I'll make that change here on this
Sure.
document.
Please, Judge. Thank you.
All right, so Mr. Johnson, what that means in your case is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
And I have the plea bargain rejection that you've signed with your attorneys that shows that the district attorney's office has made an offer of 15 years in the institutional division. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty.
Yes.
You understand all of that?
Yes.
And you want to reject that offer and have your case set for trial.
Yes.
All right, we'll get that done. Also, is there any reason to believe any evidence that you haven't either received or waiting on, or that would change this offer?
No, Judge.
And as far as you guys know, y'all asked for, everything's been received through the portal. Any media? Is there anything else that's outstanding that you know of,
Oh,
media wise?
No, Judge.
Okay. So y'all have requested and received the media, if there is any? Perfect. Okay, so I just want to make sure you understand that after today, unless there's some new evidence that comes up that your attorneys or the district attorney does not know about, I will not accept this plea agreement. So after today, it goes on the trial docket, it'll go to trial, or there'll be a plea to something else, or if it's going to be this or lower, it would be because there's some new evidence. Does that make sense?
Yes.
All right, we'll get it set on the trial docket, and we'll let you guys will get a notice by email.
Judge, may I ask this court's permission? This is my first time trying
Sure.
to case for you.
Yes, sir.
Does this court set kind of like a docket control order where there might be a motion setting or anything?
So
like that?
what I do is I'll set a pretrial
Okay.
the week before the trial date.
Okay,
And typically our trial dockets are about 8 ish cases or so. And so on the pretrial, I will go through and see who's ready, who's not ready, whatever the case is, and then I'll order those for the next week. So you would know on the Tuesday prior to what number you are. If you're at the top or close to it and there's some pretrial issues that we need to deal with, we could do it on that day. Or if it's the number one case, we can do it on that Monday before jury selection, depending on what those pretrial motions are.
Okay.
If there's something that is going to require more time, some type of suppression or some hearing that will take witnesses and more time, please get that filed quickly and I'll get it set well before that so that we can have that taken care of.
Yes, ma'am.
Okay?
All right, thank you, Judge.
All right. Thank y'all.
May be
Thank you.
excused.
Yes, sir. You go
Thanks,
back with the bailiff.
All right, we'll see.
I plead not guilty. I have not did anything. I refuse to talk about anything.
Okay, so this is cause number 25, DCCR 1133, and you're Janae Landria.
Yes, ma'am.
And so I'm going to take judicial notice of the court's file. And Ms. Landria was evaluated for competency to stand trial by Dr.
I actually
Kaplan.
have no plea.
I've received that report dated July 10th of 2026. That report has the finding in it that Ms. Landria is currently not competent to stand trial. Is there any other evidence with regard to competency?
No, Judge.
Mr. Nichols?
No, Your Honor.
Then at this time, based on the report, I am going to find that Ms. Landrieu is not competent to stand trial. I'm going to order that she be sent to the appropriate facility for competency restoration for a period of not to exceed 120 days from the day she gets to that facility. All right, ma'am, you can go back with the bailiff. That's all you got? That's all you
That's
got?
all I have.
Ms. Holmes on Jacoby Frazier.
Yes, sir.
Good morning.
Good morning. Good morning.
Diana said she has a pretrial for you upstairs.
Okay, thank you.
Where's Brett? You know?
Hey, Jacoby.
All right, you're Jacoby
Yep,
Frazier.
time to go home.
So this is cause numbers 25 DCCR 0732 and 26 DCCR 0960. Mr. Frazier is charged with obstruction or retaliation and also aggravated assault with a deadly weapon.
For self-defense.
Hang on just a second. I'm going to take judicial notice of the court's file. It includes an evaluation for competency that was done by Dr. Hamza. That report is dated June 29th of 2026. And the finding in that report is that Mr. Frazier is currently not competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
Then at this time, I am going to find that Mr. Frazier is not competent to stand trial and that competency restoration in an appropriate facility would be appropriate. Order that he be sent to the appropriate facility for a period of not to exceed 120 days from the day he gets to that facility for competency restoration, and then we'll await a report from them. All right, you can take them back.
What's up, little? What's up, little baby girl? What they gonna deal with you? Sending me a treasure?
Mr. Is Mr. Johnson here?
Yes, I gave you a note, there's a female here for him, I don't see her at the moment.
Ms. Abernathy?
She stepped outside. She's speaking to the defendant's mother.
Okay. Mr. Kimmler? You've got Jeremiah Branch.
Call the motion for accomplice evaluation.
I can't hear me at all.
I filed a motion for a competency evaluation with him. I don't know if it was filed yesterday.
Oh, okay, well, yeah, you gotta let us know before court. We don't need them.
I'm just not comfortable. If
That's fine.
If he's competent, I'm fine.
We just didn't have to bring them over this morning. If you'll let us know, yesterday we could have kept them, so I'll reset it and we'll get a
Thank you.
competency evaluation done. Mr. Brian Lane?
Yes.
You've got Heyman Brandon? Morning. Morning. All right, sir, you're Heyman Brandon?
Yes.
And this is cause number 21-36605, and Mr. Brandon is charged with murder. And what is the announcement?
Judge, I just received the insanity evaluation from Dr. Gopal yesterday and spoke to first assistant elected yesterday. After receiving that, we would like to have a second opinion, so we're going to get an evaluation done on our own, make sure that they coincide based on his criminal history and history with this particular victim.
Okay. So I'm gonna do just a normal reset. Obviously, this has been going on for a long, long time. And so if y'all can get that done, ordered very quickly.
Yes.
Obviously, Mr. Lane, if you want to be there and present for that, if y'all will coordinate, if you want to be present for that evaluation. But let's get that evaluation done quickly and then I want an announcement of the next court date.
Yes, sir.
All right, thank you. You can go back with the bailiff. See, Miss Okorafor? Did I say that correctly?
Judge, Mr. Coleman wanted to continue to handle that case. He's next door. He's messaged to be over just a second.
Okay, I'll hold it for just a second. That's on Jonah Johnson.
Yes, Your Honor.
Okay, thank you. Mr. Radford, you have Jacobian Dorsey.
Yes, ma'am.
Dorsey.
Set the case for trial.
Did you do a rejection?
I think it's already been done, but you know.
Let me, I'll check real quick and see. Was there anything, hold on, you might not have to do one. Is there anything that's,
He's already, I think I compact lawyers.
Looking.
we're not gonna call them that.
Okay, I'm sorry.
Mr. Coleman's notes look like he hasn't changed the offer or anything, Your Honor.
Looks like $2,500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one. Any objection?
No objection.
It's admitted. Is there any evidence that Mr. Gobert is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right behind you. So stop and talk to her on your way out, and then we'll see you back at sentencing.
Yes, ma'am.
Nice to meet you. Thank you.
Thank you, you as well.
Mr. Lane, you have Lisa Pratt.
Ready, Your Honor.
To you. being all aware.
Judge,
Yes,
he
sir.
ended up having to put Mr. Riley in the chair, the front chair, because he's banging his head and to hurt himself, so he got him in the chair back there.
Okay, did he ever?
No.
Then don't worry about it. Y'all can just take him back. Let me put that on the record about Mr.
Riley. Corbin Riley.
That's right. Mr. Riley refused to submit to your analysis, had to be put in the chair because he was banging his head and being, trying to hurt himself, and so gonna go ahead and have him. And he did admit also,
Smoking marijuana last
to at least smoking marijuana last night, if not anything else, so we'll go forward that way. Okay. Mr. Smith? Is Mr. Smith here? Who's Mr. Smith today? On Lisa Pratt?
Excuse on the screen.
Yes, sir, thank you. Yes, correct. That's to do this, get the pre-sentence report done. Do you mind signing that for him, please? All right, ma'am, you're Lisa Pratt, and will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Pratt, in cause number, I have me pull the right one up, I'm sorry.
Move stands for the board.
Okay. And are we just going on count one with the, and
We are, Your Honor.
okay. Ms. Pratt, in cause number 24 DCCR 1460, the state's elected to proceed on count one only. It alleges that you committed the state jail felony offense of theft of property with previous convictions from April 1st of 2024. It further alleges that you were previously convicted of theft June 30th of 2023 in two different cases on that same date. And how do you plead to that charge? Speak up. Are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane?
Yes.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And the agreement that you've reached, it looks like it's for a 12-month term in the state jail prison. And you guys have asked me to reset your case for sentencing for a short amount of time so that you can have a final appointment with regard to the issue on your leg or your knee. Is that correct? Or ankle? Ankle. I want to make sure you understand. How long, when's the next appointment?
August the 24th. Something, yeah.
Ma'am?
It's not till August.
Okay.
You said August 24th.
I might can get it moved out. I mean, I don't know how that falls. Today's the way.
All right. You'll think of- Okay, so I'm going to state tenders number 1.
No objection, Your Honor.
It's admitted any evidence that Ms. Pride is not competent.
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yeah.
Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing. I don't need a pre-sentence report. And I will reset it to the August the 31st. It's a Monday. There's a few things that are very important about that. So if you are arrested for anything between now and that court date, I do not have to accept this plea agreement. Things could obviously be worse. Do you understand?
I do.
Also, if you don't show up for that court date, obviously things could be much worse. I don't have to accept the plea agreement. You understand as well? All right, then, we will see you back at sentencing. You're free to go.
Thank you.
Mr. Kimler, you've got Evelyn Odom.
Fire department.
Thank you. Second, finish this. And we're going on a lesser, looks like.
Yes, just a straight evade.
Good morning, ma'am. Are you Evelyn Odom? And will your client waive the formal reading of the indictment?
So wait.
Ms. Odom, in cause number 26 DCCR 0403, the state has elected to proceed on the lesser included offense of a Class A misdemeanor evading arrest or detention, and that is from February 8th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes,
Do you fully understand them?
yes,
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
yes.
And it's for 30 days in jail that would be sentenced today. Is that correct?
Well, she has a job. Explain to the judge.
Well, I mean, just got a job. It's really hard for me to get a job, I guess, because I'm an age. And so I really would like to put in 2 week notice. It's for CalCam. It's like just flagging the parking lot. It's $15 an hour. So I've been looking for a job for months. So if I put in a 2 week notice, then maybe they would hire me back. I mean, just because I haven't done that.
Okay, so we just need to reset for sentencing for 2 weeks. Okay,
You don't show up.
I'm coming out with you here.
well, I'll go through that with you in just a second. So it's for a 30-day jail term, and are you a US citizen?
Yes.
State tenders number 1. It's admitted. Is there any evidence that Ms. Odom's not competent? All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for 2 weeks for sentencing. So that'll be on Monday, the 27th of July. And so you'll need to be in court that morning. We'll go forward with sentencing at that time, and then you'll go serve your time. It's very important, obviously, that you're here on that date. If you don't show up, I don't have to take this agreement. Things could be a whole lot worse. Also, if you are arrested for anything between now and when you come back, you run the risk of me not accepting the plea agreement.
Yes.
Do you understand?
Yes.
All right, then we'll see you back at sentencing in 2 weeks. What about Jose Lopez? Mr. Kimler? Yes. Good morning.
Good.
And would you please state your name for the record, ma'am?
Maria Morel.
Speak up, please.
Maria Morel.
Thank you, Ms. Morella. Would you please raise your right hand? You swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English.
Yes.
Thank you. Sir, are you Jose Lopez?
Yeah.
Yes.
And Mr. Lopez's case is set for trial to begin with jury selection next Monday. In cause number 25 DCCR 0211. Charged with solicitation of prostitution. And what is the announcement?
Your Honor, I would be ready, but I have the appointment with my retina doctor in the Woodlands on the 22nd. It's taken me like 2.5 months to get the appointment. I haven't been there in like a year, so I need to go.
Did you file a motion for continuing?
No, it's set at 2 o'clock. I just checked my calendar this morning on that. I mean, I can file one. I could pick a jury, but I would be unavailable Tuesday to try the case. I could come back and try it Wednesday.
Okay. Ms. French,
State's ready, Your Honor.
okay. And so your appointment is on the 21st?
22nd at 2 o'clock.
The 22nd is Wednesday.
I think it's
Wednesday.
the 22nd. It's the 22nd. It's not the 22nd. So that would be Wednesday. I was thinking it was Tuesday. Okay. At 2 o'clock. I know that. What did I tell you? That I told you? You're gonna drive. She's gonna drive me. I guess. I'll
So,
let your eyes. You can't see when you.
so I guess if we needed to, we could pick a jury Monday afternoon. We could work Tuesday afternoon, possibly even part of Wednesday morning, a couple hours, maybe
Yeah, so I'm on the road about 11.
11. And then we have all day Thursday. So we still, I would think on this type of case, have plenty of time.
Yes, Your Honor.
Okay, and it looks like the rejection before was for a 3-year deferred probation. Mr. Lopez, I want to make sure if we go forward with trial next week, that I will not accept any plea agreements after today. Do you understand?
Yes.
And do you still want to reject that offer for probation and go forward with a jury trial? Okay. All right, then I will number the case tomorrow after docket. If we do go to trial, will you have you'll have your own interpreter for him?
She translated.
Okay. Okay, all right, we'll see y'all next week. Stay in touch with Mr. Kimler. He'll let you know what time to be back or what order the trials are for Monday. All right, you're free to go. Thank you.
Okay.
If that's your comment, I mean, I'll take it.
Okay. Oh,
Instead, I'll just give them and come back with his very expensive trial, so we can do his vision. Okay. I'm using my chin as a table. Okay.
Mr. Kimler, you've got a sentencing on Ibriana Bell. Good morning. Are you Ibriana Bell?
Yes, Laura.
And Ms. Bell was previously in court, entered a plea of guilty to theft of property with previous convictions. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, sir, we have.
Any additions or corrections?
No, Your Honor.
All right, Ms. Bell, how old are you?
25.
You're 25 and you're already adding up some history that started as a juvenile. I'm going to go along with this agreement, and I really, really hope that you use this as an opportunity to do better for yourself and to break the cycle of what's been going on with you and your family. Looks like from what I can tell, everybody in your family's been to prison or in trouble. And so you can at some point continue doing all of that stuff and end up like that, or you can say, I'm gonna do something different with my life. And that's gonna be up to you at this point at your age, right?
Yes, ma'am.
It's not fair that things happen the way they did, but you're an adult, and so you can make those decisions for yourself at this point, right?
Yes, ma'am.
So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made and find you guilty of theft of property with previous convictions. Sentence you to a term in accordance with your agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 3 years. You're ordered to pay the $500 fine as well as the $221 in restitution. And actually what I'm going to do today is I'm going to reduce that fine to $250. I want you to succeed, and I don't want the money to be the issue. I want that restitution paid off first.
Yes, ma'am.
Okay. I want you to get a job, and I want you to pay that off as quickly as you can, and then do everything else that you're supposed to on probation. If you do everything you're supposed to, then for all practical purposes, your case here in court's over, and you'll be able to serve that 2-year sentence while you're out on probation.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you'll be brought back into court, your probation revoked, and you'll be facing that 2-year sentence that you've already agreed to. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. So if you'll just have a seat here in the courtroom, probation's going to call you up to her desk to go over your paperwork. Okay, good luck to you.
Thank you, Your Honor.
You've got, oh, did I just hear you call Del? He's, okay, I'll do that in just a second. What about Angel Mata Rodriguez, Mr. Kimler?
This on probation matter now.
This is Mr. Smith's on Angel Mata Rodriguez. Good morning, sir. Are you Angel Mata
Yeah.
Rodriguez? And
My proceedings.
this is 23 DCCR 1106. Mr. Rodriguez is on probation for evading arrest or detention with the use of a vehicle. Motion to revoke's been filed. What is the announcement?
I anticipate being able to discuss it with Mr. Smith this morning, Your Honor. I don't know that we have to have a hearing. I think he's picked up a new case. Is that right? I honestly, I don't know. Your Honor, Mr. Smith is around. He's dealing with crisis from over the weekend. He is here if we need him, but I've got his file, and there's an
Why don't I hold it?
Yeah,
Y'all can just take a look at it. Yeah, and if he needs to run down, or if y'all need to reset, just let me know, but I'll hold it for now. This is the kiss.
I just realized that.
And then Jorge Del Fiero.
Wait. Your hands.
Discovery. Okay. Good morning, sir. Are you Jorge Del Fiero? And will your client waive the formal reading of the indictment?
Sure.
Mr. Del Fiero, in clause number 25 DCCR 0892, you're charged with the third-degree felony offense of assault family violence by impeding breath or circulation from January 31st of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Kimler?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to participate in AA as well as anger management. Have no contact with the victim.
So I put direct contact.
Direct contact. You would be able to use the Family Wizard app or program to communicate with regard to your children. Do you understand? Okay. And do y'all use that already?
No, ma'am. I go straight to mom, but I'm even having issues just to see my son.
Yeah, so it's a great, here's the thing, that is a great tool. It protects you and her both because it takes everything that it has a calendar. If there's a doctor's appointment, if there's a soccer game, if there, whatever it is, if you need to find out information, you can both input information. It's like an email program, but everything's saved. So everything
Yes.
you say saved, everything she says saved. She can't say you said something you didn't, so, and vice versa. So
And what if she tried to get in contact with me or like just without using the app? What do I do about that?
hang up and say, if she texts you, say, use Family Wizard. And that way, and keep that, forward it to your attorney so that if she comes back and says, oh, he contacted me, you can have whatever you need to protect yourself.
Yes.
Okay, I don't even
And
know.
also, I know she worked. You know, her mom sells drugs and all this. She be having my son stay.
Objection. Your
So,
Honor.
here's the thing. If there's issues, you need to go through family court. All right, you need to talk to Mr. Kimler, get a lawyer, get all that worked out another way. I don't have any say so over any of that. All I have is say so over you. Okay, so if you want to stay out of prison on this probation, you got to follow these rules. And if you need to go take care of some other things so that y'all have rules to live by down in family court, then you need to get that taken care of as quickly as possible. Okay, so it looks like also,
Can I help you out, Your Honor?
yes, please.
Defendant will pay 100% of the cost for 5 years for the Our Family Wizard program. And also agreed for probation to do an assessment to help him with any needs they may be able to help him with, refer him to.
So pay 100% for both of them?
He's paying the total cost for 5 years.
Okay, and that's y'all's agreement?
Yes, Sean.
Okay, that's good because it helps everybody. All right, you understand that all of that is the agreement. Do you also understand if you're not a US citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Mr. Del Fiero is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing.
Yes.
You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there.
Yes.
All right, we'll see you back at sentencing. Thank you. Thank you, Ms. Manchin. I'm sorry, what?
Not to leave just yet.
Yeah, they may not have gone through, so don't tell them not to leave yet, just in case. Please, ma'am. Thank you.
Just to let the court know, I do have Trooper Lucio here for that hearing on all the elements. I'll just call Ms. Kane on probation whenever you're ready, but it will be very.
For the 11 o'clock hearing?
Yes.
Okay, yeah, if we get done beforehand, I'll definitely start that early. Thank you.
Wait to see if it. Oh. We're just having a short. No.
See, is Mr. Morgan? Good morning, Mr. Morgan. I'm William Nesbitt.
Yes, sir.
Right, the new office. Do you need it?
My name's Matt
Hi.
Novak. I work for Paul Morgan.
Oh, I'm sorry. What's your name?
Matt Novak.
Govak?
Novak.
Novak.
Yes.
Novak. Good morning, Mr. Novak.
Morning, Judge.
And sir, are you William Nesbitt?
Yes, ma'am.
And this is cause number 23 DCCR 2098. Mr. Nesbitt's charged with aggravated promotion of prostitution from February 5th of 2023. And what is the announcement?
At this time, we are not ready enough. I talked with the state, there's a newly assigned case, so we're fine with giving the state a chance to review everything and then go from there in terms of doing a plea negotiations with this position.
And the reason, Your Honor, I noticed there was an offer made back in June of 24. Of course, that was before the arrest and incarceration in Harris County. The reason that Mr. Nesbitt's bond had been revoked and increased.
Okay.
And so I need an opportunity to review what's taken place
Sure.
with TDC and make a new offer, because obviously the 5-year TDCJ is off the table after that.
Probation. Count 1 alleges that you committed the offense of driving while intoxicated with an open container, March 22nd of 2026. And is that true or not true?
Oh, true,
I'm sorry.
true.
True. Count 2,
We just want to avoid it.
not if it's unagreed.
Oh, okay. That's true. You're right. Sorry.
Count 2 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you became intoxicated March 22nd of 2026. And is that true or not true?
True.
And then count 3 alleges that you are behind in your court assessed fees as of April 29th of 2026 in the amount of $710. And is that true or not true?
Oh, not true.
Okay.
No, it's as of that date, not now.
Oh, other day, okay, true.
It was true as of
Sorry.
that date. Okay.
Yes,
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
correct,
And did you plead true to those counts because they're actually true?
correct,
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case so that the probation department can do an updated report, and we will come back for a sentencing hearing. Anything you think is important for me to know, be sure and get that information to Mr. Kimler. He'll present it to me on your behalf when we come back for sentencing.
yes, ma'am.
And make sure do you need to talk to him today? Okay, just stay in touch with your probation officer. Yes, sir.
I have one question, I know I have the ankle monitor, is there any way I can get a patch instead for monitoring?
The patch doesn't do alcohol.
iPhone?
Yeah, so that's why you've got this cram device on, is because that's the one that tests for alcohol.
Okay,
Okay, so at least until sentencing, we're gonna keep it the way it is.
yes.
Okay, all right, we'll see you back at sentencing. So why'd y'all do paperwork on Malik Ellis?
It's unagreed. There's one counts.
I know it's for sentencing, but I see paperwork.
Yeah, I just did it. He's pleading open.
He already did. Here for sentencing,
No, that was when we were gonna have a hearing.
but he already entered his pleas. It's just a hearing on sentencing.
He pled not true, that he's pleading, he changed the plea to true.
think if Okay.
The paperwork because he's changing the not true to the truth.
Thank you.
Yeah, I just did it.
That's nice.
Is that the same one?
Appellate certificate is in there. Too.
So it's now agreed?
No, it's no agreement, he's just pleading true, pleading open.
Gotcha.
He's not happy, Judge.
You could have fooled me.
I just want to keep you informed.
Thank you very much for that information. Yeah. Which makes it all the more believable that he was not nice to probation. You know what else I want on him? Riley? Riley or Riley?
Riley.
Yes, ma'am. For sure. And substance abuse and assessment as well. Yeah, he admitted to at least marijuana, and there was some talk about fentanyl as well. So I want substance abuse as well as mental health, and he smoked last night. So I'm not sure if there's something else going on that has to do with that as well. So. All right, Malik Ellis. Let me get this pulled up so I can make the new notations. All right, you're Malik Ellis. And Mr. Ellis was previously in court in cause number 1726733, entered pleas of not true and a motion to revoke probation. It's my understanding that there has been, that it's still, we're here for sentencing. I've gotten the pre-sentence report, but it's my understanding that he's going to enter pleas of true to some of the counts, as change his pleas. Is that correct? And so will he waive the formal reading of that motion again?
So
So let's go through the motion again. Mr. Ellis, so it looks like before you pled true to counts 3 and 6, and you're on probation for the second-degree felony offense of aggravated assault with a deadly weapon. That was a 7-year deferred probation that was extended for 2 years. Let's go back. Count 1 alleges that you committed the new offense of possession of marijuana, a Class A misdemeanor on November 18th of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to report to the probation officer your change of address. Is that true or not true?
Not true.
Count 2 is not true still. Count 3. I'm making the modification here on the agreed punishment recommendation. Mr. Kimler, y'all wrote in 2, but he pled not true to 2 just now. So I'm
there
gonna
wasn't.
He was going to.
on which counts he was gonna plead true to. Y'all
Everything.
wrote in 2. I'm marking through 2 because he pled not true.
And I'll put on evidence of that for the court judge.
Okay, and then count 3, he already pled true to. Count 4,
We abandoned, Your Honor.
state abandons. Okay, and then count 5 alleges that you possessed an illegal drug, namely marijuana, and that you were in possession of it November 18th of 2025. Is that true or not true?
True.
And then you already pled true to count 6. So today you've changed your pleas and pled true to counts 1 and 5, and you do that freely and voluntarily. And did you plead true to counts 1 and 5 because they're actually true? All right, then at this time, I'm going to find counts 1, 3, 5, and 6 true. And Ms. Malfino, you have evidence with regard to count 2?
Very briefly, Your Honor.
Yes, ma'am. And would you please raise your right hand, ma'am? Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And if you'll just state your name for the record, please, ma'am.
My name is Shay Kane.
Thank you, Ms. Kane. Go ahead, Ms. Malfino.
Thank you, Judge. Ms. Kane, would you please identify what you do for a living for the record?
Yes, ma'am. I'm a community supervision officer for the Jefferson County Adult Probation Department.
And how long have you been with the department?
I have been with the department for a year, but I've been a probation officer for about 3 years.
Okay, and do you have occasion to know a Malik Jamal Ellis?
Yes, ma'am.
Do you see him in the courtroom today?
I do.
And is he one of your probationers that you supervise for this court?
Yes, ma'am.
And as a condition of that supervision, was he read all the rules and conditions, gone over those with him of what the court expected his behavior to comply with while on probation?
Yes, ma'am.
Was one of those that he at all times provide you with an accurate address of a residence and location of his job, et cetera, so that the community supervision department and thereby the court could find him at any time?
Yes, ma'am.
And if he changed this address, was he told or informed that he needed to indicate such to the probation?
Yes,
Based on your review of your file and your contact with Mr. Ellis, the defendant, did he change his address and report such to you?
according to the offense report that I received on November 18th.
Hang on just a second. It's okay. We'll just wait till he calms down a minute. Maybe they'll come get him. All right, go ahead.
According to the offense report I received on November 18th, it had appeared that he gave the officers a different address on the report itself. And based on that, he had never told me about any different residential since I've been supervising him.
And based on your supervision, you also became aware that he was arrested and has now pled true to possession of marijuana back in November of 2025, correct?
Yes, ma'am.
Would this have been obviously in violation of his probation?
Yes, ma'am.
And in discussions between you and I last week, we decided not to bring a lab analyst to prove that up, even though we have the Trooper Lucio here in court today, based on the fact that 2 days later, he tested positive for shedding marijuana, correct?
Yes, ma'am.
And do you have some other thoughts that you would like to share with the court at the appropriate time with respect to what your position is as to continuing him or revoking him off this probation?
Yes, ma'am.
And can we hold on that for a second?
Yeah,
You do
yeah,
have additional for the
Yes,
court.
ma'am.
And Judge, I'd like to just wait following cross-examination, also ask at the appropriate time that with the thanks of the state, that trooper be released this morning. He's here in court.
Any issue with the trooper being released? Thank you so much for being here, sir. You're free to go. We appreciate you.
Thank you, Judge.
All right, Mr. Kimler, do you have any questions of Ms. Kane?
Just want to be clear. So he filled out some paperwork and listed an address that was different to the one he reported to you.
It appeared that he told the officers at the time he was arrested, what I read on the officer report, it was a different than what I had in my system. It was 845 Madison that I had, and it was a different address listed at the time he was arrested.
No further questions.
All right. No, ma'am, we're not. All right. Mr. Any other witnesses then?
I don't believe so. I'd like to cross-examine that witness if they're called, but
Yeah.
I think I know where that's going.
Okay. Do you intend to call any witnesses?
Well, I guess I can call Grace. She wants to talk, so.
Well, I mean, is it
Let's look at the officer.
no, go ahead. With regard to what issue?
Where's your grandmother?
Oh, she was just there for the change of address part. She just there for support.
Okay, that's fine.
What explanation? I'd call Mr. Pelletin.
Raise your hand. Well, did they already swear you over here today? All right, go ahead.
What explanation do you have for the difference in the addresses?
It must have went out my ID. My ID say my mama address, but I stay with my grandmother. When they came to pick me up for my warrant, they picked me up at 845 Madison.
Okay,
But your driver's license, your ID says what?
4751 Elton Road. That's my mother's house.
okay,
But that's not what you
I
said.
stay with my grandmother, which is the house that's on fire.
okay. You know, it's a law that you change your license when you
I
move.
ain't know what-
So you can see the kind of issues that gets you in if you don't.
That's my-
Right. So it's very important that you take care of that. All right, anything else with regard to the actual counts?
Not from the state.
Okay, then at this time, I'm going to find
Yeah.
counts 1, 3, 5, and 6 true. Find sufficient evidence to find Mr. Ellis guilty. Mr. Kimler, what is your position with regard to punishment?
Well, Your Honor, this is from 2017, so I guess he's been on probation. I'm approaching 10 years perhaps. I think it was extended one time. Obviously, he's had issues on probation, this latest one having to do with marijuana. I would just observe that he was negative today in court on the drug test. I guess he has at least refrained from using marijuana since this last incident, and the last time he was tested, and tested positive. The court, as it's presented, has the options, is presented to either keep him on probation or let him discharge or revoke him. I think there's a middle position where he could be unsuccessfully discharged from probation without being revoked. That may be an option that the court would explore instead of having just at the end of this period of time revoke him and send him to the penitentiary. There's an option to unsuccessfully discharge him from probation. And that would be what I would suggest if the court's inclined not to let him to sanction and not let him stay on probation, but to unsuccessfully discharge him in lieu of revoking him and send him to the penitentiary. You got anything you want to tell the judge?
How long, hold on. What's the time frame on getting the MRT class done? How long is that?
How long is it?
Process.
It's about 18-week course. It's in the probation office itself.
How many weeks do we have left? Is that something that if could he get started on that next week? If that's, I don't know if that's where I'm going, but
Yes, ma'am.
hold on.
We would just have to buy the book, and so we can get him into the program.
Ms. Malfina?
Judge, I would defer to anything Ms. Kane has. We've spoken multiple times about the case. I know she's tried everything. I'd just like her to let the court know her thoughts.
Well, we can't extend again, can we? Or is there any time frame left?
So he's at his 9 years
So we could do one more.
at the very, yes, ma'am. That would be the max that we
Gotcha.
have left.
Okay.
And he has also been to ISF cognitive track as well. But as far as what I would possibly recommend would be to put him on the high medium risk caseload for the rest of the entirety if the court allows, 0 tolerance, and possibly place him on the drop program to continue the more in-depth testing if the court would allow.
Anything else? Ms. Malfina to add to that?
Judge, I don't have much. Of course, I would defer to Ms. Kane and the court. Obviously, the state is somewhat frustrated with Mr. Ellis not taking initial responsibility. That's what I think people should get favor for instead of having a trooper have to be here. And thankfully, we didn't have a $3,000 plane ticket for a lab analyst to then what he then wanted to come in and admit. I would have rather him taking responsibility. And I don't say that in the context of disavow him of his rights to contest it. It's just that if he's
No, it's a
not,
very frustrating.
if
thing
he's
for
not
me
being
as well, and
forthright with
it's-
the court, should he have the benefit of the continuance on probation is all, not in the context of a not true. I understand that.
I wouldn't take the blame for that, if I'm not, Your Honor, in a way, in dealing with these cases that I perhaps advise my clients.
I know that's something probably needs to be addressed. We've talked about recently on several of them because it's very frustrating to have people come and take time out of their day, out of their work. The state have to expend that just to quote, set it for a hearing. When if it's going to end up, if somebody did something, they need to take responsibility for it. It goes over so much more with me, I think with the state, with probation, and it should be something that someone is encouraged to take personal responsibility instead of saying, let's see if they can prove it.
If I might, I'll try to address that in the future.
I appreciate
I hate
it.
him to be warned by something that I probably recommend.
I mean, you've been on probation for so long to be making these kinds of mistakes, you know? I could revoke you right now and send you to prison for 20 years. That's how serious this is. It's not a game. And I know you've been on it a long time, but, I get the whole argument, smoking marijuana is not that big of a deal. Well, it is if you're on probation.
It wasn't like that.
Well, you got arrested.
No, I'm saying I made a mistake, but it wasn't, I don't just smoke weed,
Well, but you have because you've tested positive a few times. So I understand that maybe you don't all the time like some people, but you have. And you got arrested for it, for having it. And so here's what I'm gonna do, Mr. Ellis, and I want you to take advantage of this because after all this time, you don't have the conviction on your record. You're about to get the opportunity of a lifetime. You've already gotten a huge opportunity. When I do things like this, what I'm about to do, and you don't take advantage of it, it is typically going to be a whole lot worse than if I were to just revoke you today. So I want to make sure you understand that You're being given an opportunity, finish this probation and hopefully not have any more issues, because it's gonna be very serious if you don't. So I'm going to find that you, again, entered your pleas of true to counts 1, 3, 5, and 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke the probation. I'm not going to do that. I'm going to extend it that last year that we've got to extend it. So you've got 1 more year. You will be on the drop program, so you'll be tested more frequently. You're going to be on the high medium caseload, which means you'll have to report more frequently. That's the price you pay for getting in trouble, but it's a whole lot better than going to prison and having the felony conviction. If you do everything like you're supposed to between now and the end of that next year, you're off probation. If you don't, you're in prison. All right, any questions?
Okay.
But for the court also order the MRT class that you had mentioned.
Yeah, so the MRT class was already ordered. I want that started within 30 days.
Yes, ma'am.
So you need to get a job if you don't already have one. You need to do whatever you do to buy that book. I want that class completed. No questions asked. I don't want you waiting until the last minute. It's 18-week class. I want it started within the next 30 days. That's in order. You understand? If you have any questions about any of your other conditions, don't wait for probation and then say, well, they didn't tell me something. Go say, am I doing everything I'm supposed to be doing? I don't want to go to prison. Okay.
One person.
What's that?
On the fees, but what am I supposed to be paying? 'Cause I keep hearing
I don't-
supervision for you.
So here's the thing, talk to them. They can explain, there's different, you had fees, you have fines, you have different parts of that. You're supposed to be paying it all. And certain things that you pay go to certain parts of that. And they'll put it towards different things. Talk to your Miss Kane, will explain to you what you've paid, what it's gone to, and what you still owe. Okay? But just ask her. All right? Okay, you're free to go. Thank you.
Thanks.
They're on Toy Frazier, Mr. Gertz. Are y'all doing paperwork?
Miss Alvino has been otherwise occupied, but.
I don't need to like that. Get in there with that before I sign it, but I do. Let Judge.
He's already signed the paperwork.
Okay, okay, I'll just ask for a little bit raise and.
All right, let me do this. I forgot to. No. This. What did you just put true to on that other one? Thank you.
I think how you just made it.
We didn't even talk about it.
All right, are you Toy Frazier?
I know. Deal with restitution.
And we are client with the formal reading of the indictment.
We will, Judge.
You put this on third degree paper, right?
Yeah, you want it on.
You were in our budget. Oh, so we're not, we're not worried about, we have public studies. We're just doing this. Okay.
Yeah.
We can.
Okay.
Okay,
This is the.
okay, we're going back to the.
Relating to the indictment.
Got it.
Yeah, sorry. So what I did was I put it on.
I saw it. Sorry, Judge, he had made a counter. I thought that's what the paperwork was supposed to be too, which it is not. So this is the original.
I need to, he's gonna have to be sworn in, as soon as that goes through, step in front of the clerk. And are we going on count 1 only or no?
Yeah.
Yes.
Just based on the nature. And why I said, Judge, if you have anything at sentencing, it's involves the assessor collector's office and.
Okay.
If they have some thoughts to add, I would ask for a little leeway at sentencing on that.
And We also will need to establish a restitution amount, but it's just for limited to 3. Even though it's only one case, it's limited to 3 things in discovery, so.
Okay, that,
We
just
need
make sure
both understand-
probation, yeah, make sure probation understands as well.
Component that we just need to get on the record too. It'll be in the paper. Oh, birds. Discover a way to do the discovery verification. It's like, it's my first day.
That's what she said, was just started, it's this new thing. Okay, and so will Mr. Frazier waive the formal reading of the indictment?
He will do it.
Mr. Frazier, in cause number 25, DCCR 1494, the state has elected to proceed on count 1 only. It alleges that you committed the 3rd-degree felony offense of giving a false name or forging a vehicle registration from July 6th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
I did.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Nice.
And it looks like the agreement is for a 2-year deferred probation. There would be a $750 fine. There would be restitution. It says for sales tax, and that would be, you guys can work that out with probation, and we'll get that amount of restitution when we come back for sentencing. Also, this has an agreement that you would be able to travel for work. I do want to make sure you understand that that's not just a blanket. You can travel without letting probation know. You're still going to have to get permission to travel. My screen just went black, I'm sorry. You still are gonna have to get permission, or at least let them know job, dates, things like that, okay? It's not just a blanket, you can go wherever and we don't know where you are. Does that make sense?
It makes sense.
Okay,
And Judge, that was an important point in our negotiations, that he'd be required to communicate where he's going, but wouldn't have to come to the court every time and.
well, you don't have to come to me, but you have to go to probation.
And just.
So the permission to travel typically comes from probation, unless there's some issue and they say, well, you don't think it's a good idea. So you still have to go through that. I'm saying now that I want you to work, and what's the job?
Oh, I go to auctions, and that consists of going to different states, like, so when you win a vehicle, you have 48 hours to pick it up. And I have to be there, pick it up. It's a daily fee if you're not there on time.
Okay, so I'll look some more at that at sentencing. Is this I just feel like that's kind of something that has to do with the underlying offense, and that gives
And
me
we
some
made it
concern.
very clear that it would require the okay of the court, maybe not in person, obviously present here, but that
Right.
it would.
So, I mean,
require
you're
the
gonna
okay.
have to, 48 hours means you're gonna have to get with your probation officer and have that understanding that you're bidding on whatever the process is. It's, you have to have that permission before you go. All right, so if it costs money, whatever happens, you cannot go out of Jefferson County without probation giving you that okay. I'm telling you it's gonna be okay, and you don't necessarily have to get my permission, which obviously would take much longer. You have to be in constant communication with your probation officer, more so than most people, because this is your job. And if you want to be able to do it and be on this probation, you're gonna have to take those extra steps. Okay, all right, state tenders number 1.
We have no objection, Judge.
It's admitted. Is there any evidence that Mr. Frazier is not competent?
None at all, Judge.
All right, so I'm going to find, and you're a US citizen, correct? I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get the probation department to do that pre-sentence report. And then we'll come back later for sentencing. They'll get the restitution figured out. Go ahead and visit it with them when you're there about your job and kind of how it works, so that they have a better understanding of that. When you get on probation, then hopefully that will go very smoothly and you can know how to get that taken care of. Is there something else? Yes, ma'am.
Just if I may, Judge, with respect to what the court stated about the nature of the offense, et cetera, I would like a little room to at least discuss with the court the possibility of asking for a few other things that go along the same line with respect to auto titles, et cetera, especially with regard to Jefferson County and tendering those here at Jefferson County at least during that term of probation, based on the fact that he is indicating to the court that it's still going to be a type of business that he's in. And I don't want him to be surprised by that.
Yeah, no, I mean, we'll see what all comes back, but once I have a better understanding after reading that pre-sentence report, there could potentially be some additional conditions.
Right. Thank you.
Okay, all right. Stop and talk to probation on your way out of the courtroom, please, sir.
A courtroom filled with serious felony cases takes an unexpected turn as defendants fight competency rulings, reject plea deals, and face life-changing decisions. But throughout the hearing, the judge delivers one consistent message: every choice comes with consequences. The morning begins with two competency hearings. In the first case, a defendant insists she has done nothing wrong, but the court relies on a professional psychological evaluation, finding that she is not competent to stand trial. Rather than moving the case forward, the judge orders her transferred to a competency restoration facility for up to 120 days so she can receive treatment before the criminal case continues. Moments later, another defendant facing charges including aggravated assault with a deadly weapon receives the exact same ruling after his own evaluation reaches the same conclusion. The courtroom then shifts to Jacobian Dorsey, who's charged with manslaughter. Prosecutors offer a 20-year prison sentence, but Dorsey refuses the deal and chooses to take his chances at trial. The judge carefully explains that because of prior convictions, he could face a much harsher punishment if convicted. Even after Dorsey mentions that one of his previous cases is on appeal, the judge makes it clear those legal questions can be addressed later, but today, the case is headed toward trial. Next comes Alexis Yell, appearing on a motion to revoke probation after being arrested for driving while